So we've got a new response just in from former President Trump and Rudy Giuliani to a lawsuit over the Capitol riot. You'll remember that lawsuit was filed not long after the insurrection by a group of House Democrats. And the former president is digging in on a couple of arguments, including he says that he did not incite people to violence and that his statements are protected speech. The same lawsuit is getting another new response from one of the far-right groups responsible for the riot, too. I want to bring in NBC's justice correspondent Pete Williams on this. Pete, let me take this in a couple of chunks here. Let's start with the former president. What else can you tell us about the new response from him, from Rudy Giuliani, and where that lawsuit goes?
So the former president's response mirrors the argument that he made 2 days ago in response to another lawsuit, the one filed by Congressman Eric Swalwell. What Trump says here is that he was acting in his official capacity when he urged Congress not to declare Biden the winner of the election, that he did not incite people at the rally to violence, and that his statements are protected expression. Giuliani says there was no conspiracy to try to get people to attack the Capitol. Nobody was trying to encourage that. His response says, quote, "The conspiracy theory defies all plausibility and believability on its face. In fact, it makes all of the theories of election fraud look tame by comparison." And his lawyer says the use of the phrase trial by combat, which is something Giuliani said during that rally on the Ellipse, referred to the future legal challenges, not to what was happening at the Capitol. Now, also the Oath Keepers, who were also named in one of these lawsuits, their lawyer makes this novel argument. He says the Constitution and federal law don't specify what individual House members are to do when the electoral votes are counted. Therefore, they had no formal role or official conduct that could be the target of interference. This lawyer says the House of Representatives, has a duty to observe the vote count, but that's an institutional responsibility, not one belonging to individual members. So basically, he says they have no right to sue. And to the extent that the counting was interrupted, the lawyer for the Oath Keeper says Congress has only itself to blame because it was objections raised by members that stopped the vote count, not the Oath Keepers.
Pete, you called it a novel argument, I believe. What does that mean for its potential legal merits? Can you infer anything based on the judge in this case?
Well, it's a long shot, I would say, to put it mildly. This notion that there's another theory, by the way, that I didn't get into earlier, but it's the theory that because the president was impeached and tried and acquitted, therefore, he is not subject to any other legal action based on the arguments that were made in the impeachment. Now, that's the flip side of what the Constitution says, which is if a president is impeached, tried, and convicted, then the president can subsequently be indicted. So the president's lawyers are saying, well, the opposite must be true, too. I would also call that a novel legal argument.